Hey everyone, thanks for joining us today. We're going to get started in about 5 minutes just to give everyone time to join the stream. So feel free to grab some coffee, grab a snack, grab some drinks, and then we'll get started shortly. Thanks. Hey everyone, thanks for joining us today. I'm going to bring up Kyle Kertz, who is your host for today.
Good morning, everyone. Welcome to Startups in the Law. We do Startups in the Law first Tuesday of every month. This is a little educational webinar that my law firm puts together that is meant to help you sort of orient yourself as well as give you a better legal foundation and better understanding of legal foundation as you start and grow your businesses. Just to give you an idea, I am one half of JonesKertz. I'm the managing partner of our Texas operations based here in Dallas, Texas. And Matt Jones is based in Oklahoma City. He handles a ton of tech deals, and he is, getting to the point where he's almost the go-to guy for Oklahoma tech deals. We are rapidly growing our practice right now, but at the same time, I want to let you guys know that, this webinar that we're doing it's not meant to be a sales pitch. It's really meant to be educational because, the idea here is better education, better foundation, more successful startups. The idea here is to lower the failure rate of new businesses, especially tech businesses, which have a relatively high failure rate. And we hope to do that by educating you on what kind of documents you need, what kind of money you should spend when you're getting certain things, and how much work you need at what point in your business. And just to give you guys an idea, if you need my contact information, it is right there, Kyle@JonesKertz.com. You can call me on my cells, 210-854-9246, to ask me any questions that you might have after we're done with the presentation. To give you an idea of what we're going to be doing today, here's some of the topics. We're going over employee rights from the latest US Supreme Court case that came out, I believe, middle to end of last month, as well as some basic legal updates in Texas, and then PPP loan forgiveness rundown, which is actually going to go into how you calculate whether or not you get forgiveness. So stay on for that. And then we're going to go through a pretty dense trademarks overview. But the idea is these first three are not going to take too long. The idea is 30 minutes max on the first three, and then we're going to go into trademarks overview because that is really the meat and the bulk of the content that we have for this presentation. So, by the way, if you have any questions for us, please let me know in the comments or ask Trip. He is going to be helping me conduct this today, and every now and then I'm going to stop and see if there are any questions, and Trip is going to throw them up in the comments board on this live stream. So other than that, though, when you are asking questions, just try to keep everything pretty general. Try not to make it too specific. If I feel like it's too specific, I'm probably going to say, I probably can't answer that, but send me a DM, send me an email. But anyways, we're gonna get right into it. So, recent legal updates. So, the latest case out of the Supreme Court affecting employment agreements for small businesses, startups, and not so small businesses, and not so small organizations is Bostock versus Clayton County, Georgia. This case ruled that discrimination against people who are transgender or identify as a different gender or are something other than a heterosexual sexual orientation. Really any different sexual orientation that could be discriminated against. That's no longer okay. The reality is, for the most part, most people were not saying it was okay, but the problem is in some states, there were rules that permitted people to discriminate against people who were homosexual or bisexual or transgender or gender fluid. And the reality is, this case actually does change quite a bit throughout the whole nation, you are not allowed to discriminate against people based on sex, which they construed sex to be really, gender identity as well as sexual orientation as a branch of sex, as a branch off of sex, meaning you can't really have one without the other, right? So the takeaways there are really just don't discriminate against employees or contractors for any reason related to their sex, gender identity, or sexual orientation. The ruling, however, big exception is that it doesn't apply to religious organizations. They actually said this in the opinion. They said apparently in the lower court before it reached the Supreme Court, this sort of thing had been argued that it should apply to religious organizations and ministers who, based on the First Amendment, are actually allowed to discriminate against people who might not be heterosexual or might not identify with what most people believe is their natural born gender. The reality is they did not address that particular topic in the opinion. They actually left it open for a future opinion. But I'm going to give you guys an example of what I would consider a pretty neutral, non-discriminatory sort of policy. So the idea here is, we include policies like this in an employment and staff policy, in employment and staff handbooks, as well as employment agreements, independent contractor agreements, basically telling people, hey, these are what we consider to be protected classes. We're going to treat you equal. And it'll say something like the company strictly prohibits and does not tolerate discrimination against employees, applicants, or any other covered persons because of race, color, religion, creed, national origin, or ancestry, ethnicity, sex, including pregnancy, sexual orientation, there it is, gender, including any gender identity, age, physical or mental disability, citizenship, past, current, or prospective service in the uniform for services, genetic information, and this last bit is really key, or any other class or characteristic protected under applicable federal, state, or local law. That last part actually is intentionally in there mainly to cover situations like what happens with the Bostock case. There's new law that sort of overrides whatever may really be in the part that's above that last clause. And so the idea there is we're going to put a catch-all provision in there just to make sure that the contract that we have, the employment agreement, the employment policy, the staff policy, whatever it might be, will actually survive a challenge like in court, that it doesn't properly protect individuals, that it doesn't properly do what it's supposed to, even after the law has changed it. So, Trent, do we have any questions related to any of this? These are the only two slides I have on this employment update. It's relatively straightforward. The only other thing I would say is if y'all have employment agreements or independent contractor agreements, I would just make sure that they contain language, something like this, that is broad enough to be construed as non-discriminatory, unless you're a religious organization, in which case, you're probably safe to actually discriminate, but I would just recommend that you don't. Bad PR. So, anyways. Reopen Texas measures and guidelines. Just real quick, the rule is now that you have to wear a mask to all businesses that are places of public accommodation. So you can't really go into a business anymore and not wear a mask unless you have some reason why you should be allowed not to. And there are exceptions. So the rule for wearing masks does not apply to kids younger than 10. I'm not sure I really agree with that. I think it should be, I think the threshold should be a little bit younger, but anyways, it's 10 years old. And then people with medical conditions. So if you have some sort of like emphysema, but you're not on oxygen, or you are on oxygen and you have to have something like over your face, and it's a mask would obstruct it or something like that. So be it. You probably want other people running your errands rather than running around, because people with medical conditions would already be at risk. So I don't recommend they actually go out as much without a mask on. During exercise or while not in close proximity to other people, while driving, I think that's an obvious one. While swimming, yeah, I guess. while voting. That's like this list is kind of weird. And then attending places of religious worship. This is Texas. Obviously, that's going to be one of those. Potential punishment for non-compliance is a first-time warning. And the second offense is a civil fine of $250. Every subsequent offense is also $250. The rule, though, is you can't be arrested. As a matter of fact, the rule actually says you can't be detained, which there are a few, I believe, at least one judge and then two sheriffs I know of for sure that have actually said, we can't enforce that because you're like, in order to write somebody a ticket, you have to detain them. I mean, that's a standard detention. And so they're basically, the sheriffs are basically saying, we're not enforcing this rule anyway because we can't. It's a conflict. I mean, there's a pretty latent ambiguity in the drafting of the rule itself. And so it doesn't really make sense. So regardless of what you think about wearing a mask, you're probably going to be fined if you don't. At least as far as getting fined. I don't know about your health though. There's other rules regarding large gatherings. So mayors or county judges are allowed to authorize larger gatherings than are authorized by the state. So this is sort of shifting some of the power back to the municipalities, to the incorporated cities and townships and things like that. I mean, and I think that resulted from most of the tiff with Judge Clay Jenkins here in Dallas. There's just a big argument between the governor of the state of Texas and him regarding power and what they could do and what they couldn't. And so they basically just shifted the responsibility back to the county level. Other than that, though, gatherings of larger than 10 are prohibited. You're not allowed to go to a restaurant and seat 12 people. As a matter of fact, just so y'all are aware, like each individual person that is seated there in excess of the rule, like could be fined, or the restaurant itself could be fined $500 per head for those. So I don't really recommend you do that anyway, because you'll be causing those restaurants some problems. Restaurants are required to limit to 50% capacity. Bars are prohibited from operation, which is interesting because the argument here is most of the people who would go to a bar and drink are probably just going to go to sit down restaurant and have a few beers, have a cocktail, that sort of thing. And so there are actually some businesses that are bars that are going to sue the state of Texas over this rule if they don't change it. I believe they probably should change it because I think there's a less restrictive means to which bars are allowed to operate. I mean, and when you think about it, it really, like bars, I mean, the case could go really both ways. A bar is purpose-built usually to create crowded space and create situations in which people are going to pass and touch each other pretty much. And so it's hard to social distance in a bar unless you're just limiting the occupancy rate. And so if the rule for restaurants is going to be 50%, maybe the rule for bars should be 25. I don't know. That's up to them though. If we don't have any questions over that though, I mean, that's a pretty basic run through of just some legal updates. I mean, there's really nothing else that has changed other than the fact that they've closed down certain businesses and stopped them from operating. There's something that has been coming up though over the last few weeks, and really the last 2 weeks for us in particular. We had our first client we had our first COVID affected client go into bankruptcy. Maybe I'm not wording that correctly, but the reality is this business was very heavily involved in commercial real estate, and the business went belly up. I mean, customers left them en masse, and it had nothing to do with the fact that their business offering was bad. It had everything to do with the fact that they were shut down. It had everything to do with the fact that people are scared to leave their houses, and the fact that there's a super deadly strain of coronavirus going around. The truth is, though, I think small businesses and startups need to sit down and evaluate their risk for bankruptcy right now. And the reason being is, I mean, there are situations where your customers could just straight up leave you for really no reason at all, unless you are doing something to keep them on. And the problem is, if your expenses are getting way out of proportion to the amount of earnings, or the amount of revenue that you're bringing in, you're going to put yourself in a cash crunch situation where you could potentially have to file bankruptcy, or if not liquidation type bankruptcy, the type that would help you restructure debt. The problem with a lot of startups, though, is they're not that well capitalized. They may have gotten VC money, but the truth is, a lot of them we know are for sure like $1 in, $1 out when it comes to certain days. I mean, they run razor thin sometimes, and sometimes have trouble meeting their debt obligations. And so if you are ever at risk for bankruptcy and it is related to COVID, my recommendation to you is to pay somewhere between $250 to $500 for an hour's worth of advice from a bankruptcy attorney. That attorney can tell you in an hour-long phone call or a 2-hour-long phone call what exactly your risk is and what type of bankruptcy might work for you if you need to restructure or liquidate and dissolve the company. I mean, whatever may work for you. Those people could also potentially help renegotiate your business debts. That's mainly like when you go into restructuring, what mainly happens is they sell some of your assets, maybe, but really what they're looking to do is restructure those debt obligations, restructure some contract obligations to allow for you to pay off your bills and continue operating. But the idea here is, I mean, I have to talk about it because it is going to start affecting more people. As a lawyer for startups, we are the first stop because people want to negotiate their lease agreements before they take the step to speak to a bankruptcy lawyer. And I would say that's a wise thing to do, but the truth is, I mean, we see like what is actually a lagging indicator to the general public is something that we see 2 to 3 months ahead of time. And so I'm starting to see the signs that the bankruptcy problems are actually going to be fairly bad. I mean, the debt, like the non-negotiable expenses that you have for your business are something that could balloon to the point where your business can no longer survive. And unfortunately, that is what happened with one of our clients. It was just insurmountable. There was no way to come back from it unless the company got an injection of 6 figures. And the problem was that industry was just too far, in general, like too far away from where it should have been. And so it's just, it was an unfortunate situation, but I mean, I do want to answer some basic questions that might come up when you're doing this sort of thing, if it ever does come up for you. When does it make sense to shut down and or file bankruptcy? There's no absolutes, but I mean, like I said, how much cash do you have left? How much are you earning every single month, every week, maybe? Because, I mean, you need to look at your profitability. You need to look at your expenses. I mean, you need to look at your ability to increase sales in the short term and prove to your landlords, to whoever your vendors are that you're paying, to whoever you owe money to, that, hey, no, this thing's going to be okay. Just bear with us. I mean, debts, contracts you can exit. Start looking at those cancellation policies. Start looking at the things that you can use to get out of contracts. And then maybe even go look for outside capital. Go look for venture capital or private equity. Go look for a loan. It doesn't have to be the economic injury disaster relief loan. It doesn't have to be PPP, which, by the way, both are still available, I believe. There's still some money left there if you didn't get some already and you're still eligible. And then, I mean, last but not least, a lot of people are actually looking toward donations from friends and family. We've been seeing a lot of GoFundMe's pop up And actually, I would say that GoFundMe's are actually a fairly profitable way to do that sort of thing. You would be surprised how much money you could earn or how much money you could raise for your business if you are struggling, because people care about you. And then last but not least, you can discuss potential sale of the company and its assets. If you have intellectual property that can be sold, such as patent, I mean, go look at that. If you have a product that could be sold, if you have something that could be partitioned off and sold that maybe you're not using, or just certain equipment, I mean, whatever it might be, take a look at what you have and what is marketable. And then, I mean, when it comes to a potential sale of the company, you may speak to some business brokers to discuss selling a company and seeing what that process might be like. There are plenty of people who do that sort of thing and find people to buy your business for you. So other than that, though, we're going to move into PPP loan forgiveness. So this is going to be a little more technical, so bear with me on this. If you have a pen and paper out, I would suggest you get that out now and take some notes if this will apply to you. But other than that, some of this stuff can be found online. So just so you're aware, just a friendly reminder, 100% of PPP loans can be forgiven. Eligible expenses, I mean, I believe it was over an 8-week period before, but they moved it to a 24-week period with the latest bill. And so, and the major categories are payroll, mortgage interest, rental payments, utilities expenses, with the following limitations on those in parentheses. 60% must be used for payroll costs. Used to be 75. Make sure that you are accounting for that sort of thing and tracking all of that. So the idea here originally was that you must maintain the number of employees that were on your payroll before, right? And this is the calculation. So, I mean, step one to this is you want to determine the average number of full-time equivalent employees you had for the 8-week period following the initial loan disbursement to you. That would be your start date for your loan, by the way. And then you're going to do a calculation for the number of full-time equivalent employees you had from February 15th to June 30th, 2019. And then you're going to find the number for January 1st to February 29th of this year. And then step two, you're going to take the number you get for A and divide that by B1. Step three, take the number you get for A, divide by B2. And then step four, you're going to take the largest number you obtain. Seasonal employers must use B1, by the way. So if you are a mostly seasonal employer, just scratch that B2 stuff. The results are, if your number comes out to greater than or equal to 1, you've met the employee retention requirement for payroll expense loan forgiveness. Good stuff there. If less than 1, you have not met it. And then, I mean, you'll need to see if there is some sort of exception that will allow you out of whatever requirement this created for you. So, and I'm going to talk about that here in a minute. So if you look at this, let's say you didn't get a number equal to or greater than 1. Did you attempt to rehire employees by making a written offer, which they refused? You must have documented this through email or physical paper. You have to document everything when you're doing this. And I doubt most people did it through physical paper because nobody used paper logs anymore, or paper communications really. And so did you offer, I mean, the second thing is, did you offer to rehire them with the same salary, wage, and number of hours as before? I mean, you're really going for best efforts here. I mean, I believe there is some give in the law that allows you to not hire them back with the same number of hours if you couldn't really afford to. I mean, there are certain nuances to that you can talk with your lender about, but generally speaking, like, you had to hire them on for the same number of hours as you did before, despite the fact that most people weren't going out and spending money anymore. It must be at least 75% paid during previous quarter, or reduction in proportion in difference between 75% pay and what they currently earn. So if the amount that you were paying them was below that 75% mark, from where it was before, then you are going to not get the forgiveness that you were looking for, and you're going to have to pay the difference and whatever that number went down to. So, I mean, this is all stuff that can be done on paper, by the way, and there are forms to help you online, as I'm sure your lender, if you have taken PPP, has already sent you forms for this and attempted to get you to fill it out if you have already moved all of that money and spent it. So the third category here, though, is did you have documentation of the employee's rejection of the reemployment offer? And the idea here is people who are unemployed and earning unemployment benefits are usually supposed to not take, are usually supposed to take the first job that's offered to them, because if they don't, they're technically refusing employment, at which point you should probably just report that, because they're harming you, they're causing more trouble for you. And quite frankly, that's creating a hassle, not just for you, but the whole system. It's also pretty much fraud. I mean, they're basically leeching off the system in order to earn more money, which most people were. They were earning something like, in Texas, I believe it was something like prorated to be, it was like $55,000 or $50,000 a year based on how much money they were earning weekly. If so, did you report such rejection with the Texas Workforce Commission within 30 days? I doubt most people did that. I doubt most people understand that was a requirement before COVID. If you attempted to rehire somebody who's on unemployment benefits, but anyway, you may also have a way around this, though. If the employee was fired for cause, so if they did something reprehensible and you terminated them because you had to, you should be good. I mean, you still want to use best efforts to replace that person. But I believe the law accounts for people now that if you aren't able to replace them, it should be okay so long as you can document that. So the employee voluntarily resigned, same effect. Employee voluntarily requested and received a reduction of their hours, so you're not complying with that number of hours requirement up above. Next, like staff that were laid off or furloughed may be hired back by December 31st under the grace period requirements if you cannot hire them back yet. So this is where there's exceptions to the rules previously, right? So they're wanting you to spend that money within a 24-week period. You're basically saying that doesn't work for me because our business is seasonal. I mean, take for instance, like you run an independent contracting business where all you do is work in schools. You can't hire people until fall. Or until late summer. And so, I mean, this is what the grace period is for. It's for people that would otherwise be out of work all summer or at least into fall. So that, I mean, if you hire back people by December 31st or replace employees that have left you by December 31st, I mean, you should be good so long as you're accounting for the equal number, making sure these people are working the same hours, et cetera, et cetera. So, each individual employee's pay is what matters. It's not the amount you spent in total. This is a common misconception with the law. You have to calculate whether or not you obtained forgiveness on an employee by an employee basis. It is not whether you spent the full amount and distributed X here and X there. Like you are trying to level it up, and it had to be precise. And so I think this is what most people are going to get wrong, and most people are going to get dinged because there's going to be a lot of people who thought, oh, I was going to get 100% forgivable loans. It's not going to be the case anymore. So, yeah, I mean, it appears that we have maybe one or two questions. Maybe I should stop there and give it some time. Does that include former employees turning down your offer at a lower salary? So I believe you're talking about employees who are refusing to come back. I mean, the truth is, I mean, you're supposed to offer them back their job at least 75%. I mean, if they did refuse unemployment, that creates a bit of an issue, but I believe based on my reading of the law that you would be able to obtain some forgiveness, but if it were below that 75% threshold, that you would have to pay the difference between whatever that was. And the math is, if your requirement was to pay them 75% of whatever their former salary is, but you only paid them 60, the amount that is not forgivable is that 15% difference, right? So it's not bringing it all the way up to 100, but I mean they're going to have you pay like the interest and principal on that 15% spare. So other than that, though, there are two types of forms out there for entrepreneurs and small businesses to fill out their loan forgiveness applications. These forms should be delivered to your lender. There is no state agency address for these things. It is drop them off at your bank, the person you open your PPP loan account with. And I can't stress that enough. But I think a lot of people are just going to expect to do this with their IRS forms. Maybe that will be the case later, but it's not right now. For the most part, everyone is directing you to your bank. And so if your bank does not have a standalone form explaining all of this, there is a government form on the Treasury Department's website that you can go get. There is, and just to give you an idea, the difference is for more complicated businesses and businesses that are where it's not a sole proprietorship or self-employed individual or self-employed individuals or just independent contractors. I mean, the long form application is probably going to be your best bet. Either way, you could probably use the long form application. But for those people who are claiming themselves, for instance, as I mean, they're running an LLC, but it's taxed as an S corp. You're probably going to file the easy application rather than file the long form application. If you're the only employees, or at least one of only a few employees. And I mean, the rules are actually, there's like 3 separate categories for the easy application. I recommend you just download it online, offline, and read through it to see if it applies to you. So without further ado, we got through that pretty fast. Are there any more questions related to any of the 3 topics we just discussed, or should we go on? All right, in that case, I'm going to go ahead and proceed. We're going to talk about trademarks. So just to give you a general idea for what we do for a living as startup attorneys, we see a lot of trademark work because a lot of people have a brand name, a catchphrase, a slogan, a logo that they want to make it an actual asset. They want to register it with the USPTO, and they want that for a number of reasons, which I'll discuss right here. So the bottom line is really that assets such as trademarks have value to potential acquirers and investors. So similar but slightly different to, say, a patent, a copyright, something that is marketable and has tangible value based on what you are able to earn off of it is an asset that somebody might be willing to factor into the valuation of your company when they're deciding whether they want to purchase it and whether they want to invest in your company. So venture capital investors, you'll hear them say, I mean, do you have anything that's patent pending? Do you have anything, do you have trademarks for your brand? If your brand is hard products, like for instance, say you're running a skincare line, might be pretty good idea for you to have a trademark for that, just to make sure that your name that you're writing, that those investments are riding on, is actually yours. And so, I mean, the goals here are, you're going to protect your business's intellectual property. You want to protect your brand name, and you want to protect the logos. You also want to protect any of the symbols you use, any of the variants of those symbols, if possible. I mean, designs. And then there are some things that are slightly different than all of the above, which is trade dress, which I'll explain here in a little bit. But the idea here is, if you obtain a registered trademark, you sort of have a presumptive ability to enforce your rights to the trademark itself and enforce it against infringement, like due to the fact that it was registered and put people on constructive notice that, hey, before you used a competing trademark, you should have actually come and seen if there was something different or something similar to what you were, or to what they were using. Anyways, so here's an example. Words, Apple, Google, Netflix, Coca-Cola. We see, like, I mean, it's pretty much when you look on the, I believe it's the TSDR or the TDSR, can't remember right now. When you look on that, you'll see oftentimes, and it's just bold block letters, the name Apple, the name AT&T. I mean, it's literally just the name of the business usually, but it can also be it can also be a string of words that you're trademarking. So, I mean, it could be words, it can be logos where there are no words, and it can also be symbols or drawings. So, if you look at, I mean, the logo for Apple, I mean, fairly similar if you're looking at symbols, drawings for what would be the brand for Puma. And then we're talking about trademarks for Amazon. So this would be more of a logo plus that brand name and that word combined. And then I included Red Bull here because I do actually want to talk about it. Red Bull is kind of a lark in that Red Bull fiercely protects its intellectual property to the point where if you come anywhere near it, they will sue you or threaten to. There are stories of their lawyers going after people who literally mean no harm to the company and are worth very little money in the grand scheme of things, and just going absolutely like bonkers over just a minor, what would be a case of minor trademark infringement, and just not letting it go. Red Bull, just so you're aware, certain companies, the brand is almost everything. So it goes back to what I said, like these assets do have value. For Red Bull, apparently the logo and the name itself in combination are apparently almost all the value. Apparently they don't make tons and tons of money off of their products. They make way more money off of sponsorships. It looks like we have a question that just came in. Trent, should I answer that right now? It would be pretty important for you to trademark the logo as well as probably the brand name when creating an e-commerce website. The reason you can trademark domain names, you can trademark certain things that you can trademark anything that's online that you're using for your business. You're also using it as an e-commerce website. So I'm assuming that there are certain products that may be branded by you, or at least that other people are selling. I would highly recommend you actually get a trademark for at least your company, like as an e-commerce website. I mean, that's a service that you're providing to people. And I mean, if you have any products that you're selling, you can also get trademark classes for those products that you're selling that you put your label, your brand name on, what have you. It's actually fairly important because a lot of it is saleable value. You're talking about, I mean, don't think of it right now as, you know, a trademark, you're investing in it, but I mean, you might not see the impact of that goodwill until you decide to sell the business or until you decide to have somebody value it. And it really goes into that goodwill portion of the balance sheet. And so I would just recommend you get that. I mean, you at least apply for what I would call a, you're basically saying that you're I mean, if you don't want to apply and just go all in and say, I want this trademark, so we're going to register it, you can basically just submit it's basically a statement of use. And it's basically like, yeah, we're sort of in the process of establishing that we have a registerable trademark. And so you can apply for what I would call it's basically a temporary or provisional application. And then what you do is you just update it and amend it once you have the proper materials and what's known as a specimen to be able to complete your application. So other than that, though, slogans, just do it. I mean, one of the most common ones and identifiable in America. Trade dress. I put this this bottle here. So Jack Daniel's is actually has a trademark on their bottle. The shape of it is so distinct, in fact, that I mean, its packaging itself. I mean, imagine if you're somebody who's ever drank this stuff. I mean, you would pretty much be able to identify this thing blindfolded based on the way the bottle is shaped. And so, I mean, they actually do have a trademark. I believe they may also have a patent on manufacturing these bottles too, but I'm not entirely sure if they do anymore. At least they do have a trademark for it though. So other than that, though, how long does it take usually to successfully register a trademark? It takes about a year minimum. So start to finish, 12 months. I mean, minimum. Like I said, the process begins. I mean, you do what is basically a trademark search and clearance. That's basically just background research. Second step is preparing and filing the application. And that really depends on what you're going for. I mean, which individual classes you're going for and which application you intend to use, which there's two main kinds. The trademark examination, which is the examination of your trademark application done by the USPTO's attorneys. And then publication, if you pass examination, you go into publication, which it goes into what's known as the official gazette. And you end up, it ends up going in through certain rounds of publication. Sometimes those get extended, which I'll explain why here in a little bit. And then last but not least, if everything goes well, you get officially registered, hopefully in a year. If anybody tells you that they can do this in 6 months or can do it in 3 months, they're lying to you. Mainly because it takes about 3 or 4 months before you even get a response back from anyone based off of from the USPTO's office, from an attorney there that they have evaluated portions of your application, which we'll talk about here in a second. It looks like I have another question. Should I try? Or maybe that was the last one. Okay. So what laws apply to U.S. trademarks? The Lanham Act governs trademarks and gives the USPTO authority to regulate trademark applications and registrations. Applicable rules are really include whether the trademark is used in the type of commerce that Congress can regulate. So it has to be interstate commerce. Just to give you guys an idea, the interstate commerce, for the most part, in modern society is almost everything. So for instance, you're running an e-commerce website. The idea there is because of the fact that you're running an e-commerce website and it is available nationwide and pretty much worldwide. I mean, it is in interstate commerce and it is not necessarily restricted to intrastate commerce. So yes, it will be available later. It is actually being uploaded and will be saved to the to Capital Factory's website or Capital Factory's YouTube channel. So it'll be available there. And so the other portion of this is it has to be distinctive. It can't be generic or merely descriptive, which we'll go into that a little more later. But it has to be something that is unique enough for you to say that you own it. I mean, for instance, you can't really get a trademark for the letters ASAP, ASAP, right? I mean, it's a colloquialism. It's something that is just in the English language that is used by everybody and is not owned by anyone. And in some cases, you do see people who will try to trademark things like, I mean, I think LeBron tried to trademark Taco Tuesday or something like that. That was bold. I mean, all it really did was create headlines and legal fees for his lawyer. Other than that, it didn't really go anywhere because you can't own that. It's used by everybody and nobody has ever claimed ownership of it really. And so, and what I was speaking about previously is called the intent to use application. You're basically filing that you're intending to use a logo, a brand name, a symbol, or combination thereof. And that you will eventually update and amend your application and bring the application basically to finalization and then final submission. So, and then, I mean, once you brought it to final submission, or if you decide that you just want to register a trademark, you just file what's known as a use in commerce application, which you get what's known as a specimen. The specimen itself, that's a clinical term, but really it's just, we need a sample showing that you've used this thing in commerce. So, I mean, put it on business cards. I mean, put it on something that you've sold, put it on t-shirts, put it on put it on your products and show that you've attempted to sell or actually did sell those products with your brand name on it in the form that you're applying for with your trademark registration application. And I mean, the idea there is, I mean, you want that specimen to be as specific to the class of goods or services that you're applying for, and not all are the same. There are more goods classes than services classes, and so I mean, you need to make sure you pick the right one for your business, and that's where we sort of come in. We help you figure out what makes sense for this today. And so the other thing that is important that is probably not as often talked about is the Madrid Protocol. The Madrid Protocol is basically, call it a treaty, if you will. It's a treaty. Anyways, under the Madrid Protocol, certain nations have agreed to honor each other's registration of trademarks, so long as you have filed for international registration. And the reason this is important actually is because, I mean, the best example of this in recent history is what just happened last month. So Netflix started a show called Space Force. This was like right after the US government had actually announced that they were, shortly after the US government had announced a new branch of the military called Space Force. The US government filed for a trademark registration for Space Force in the US only. They didn't do it anywhere else for obvious reasons. I think obviously they're not planning on operating Space Force really anywhere else unless of course they decide to start sending their contracts to Russia and not SpaceX. They ended up the way international registration of trademarks goes is usually in America, like we have pretty liberal trademark rules, which means if you were using a trademark prior to somebody else using it and you can prove that you were using it prior, you might have an argument that you were actually using it first, and therefore that person should not have a registered trademark, like with the USPTO. It's kind of a first in time, first in right rule. It's not the case with international jurisdictions. For instance, in Europe, like where Netflix registered much of its trademarks, apparently it's a first to file wins rule, which means like if somebody could potentially steal your trademark if they wanted to, it could be the exact same thing. But if you were the first one to file it, that's proof that you own it. That's actually much more similar to the way U.S. patent law works, where somebody can steal an innovation and patent it, that could have been your invention really, but they could just take it and file that, and they could own you, or they could own your invention or innovation. But anyways, the idea here is it's important to register these. You want to make sure that you are getting international registration if you're planning to do international business. So e-commerce website. Like if you've got an e-commerce website, feel free to, if you're going to register, figure out which markets you're going to operate in or sell to, and register your trademark in those other markets, because quite frankly, certain companies that are based here in the States, they have either the same trademark for companies over in Europe or Asia or South America. But sometimes they register alternative trademarks as well, because different brand names tend to work in different continents better. And so you sometimes see that with restaurants. You sometimes see that with bottled alcohol, things like that. They'll rebrand things just for marketing purposes to make them better for local markets. So other than that, though, what info is required for trademark applications? It's really fairly standard information. You're including your name, whether you're a company or an individual. You're including your address, email address, type of legal entity, and citizenship. If you're a company or a foreign company and you're registering, you have to have a U.S.-based attorney register on your behalf. So For those of you who may be listening from another country, or those of you who may be running a foreign entity, a foreign registered entity that is not a like a Delaware corporation or any corporation that has its jurisdiction based in the United States, you may have to do this if you're wanting to do trademarks. You want to include a drawing of the trademark. I mean, the words itself or the drawing itself, it needs to be extremely clear. Usually straight black and white is good, unless you are going for a color trademark, which is acceptable under certain circumstances, though obtaining color trademarks is less common than obtaining trademarks for designs, symbols, things like that. Proof of use in commerce. Like I said, you need to prove that you've used this on a product or a service. You need to prove that you've slapped that thing on your website, that you've used it on a domain name, that you've done XYZ with it, and that you've at least attempted to conduct business under that name, under that logo, under the brand. And then verified statement, it's basically an affidavit. I mean, statement that everything is true and that you're not ripping anybody off. And then payment of applicable fees. Each service and goods class is somewhere around $225 or $275, depending on the application you're filing. And here is the price schedule. So, like I said, the TEAS Plus application is going to be slightly less than the standard application, and the reason for that is the TEAS Plus application has apparently sort of a library of historical goods and services class descriptions that you can pull from to use for your application. So the idea there is it's going to cost you less because it'll take the USPTO less time to evaluate your application. If you don't think that those canned answers or those canned descriptions are going to be good enough for your application, maybe spend the extra money on doing the standard application. It's not that much more, to be honest with you, and you may get a little further with that. Who knows? The paper application has pretty much been phased out. I believe they only do applications now online. And then, I mean, these are some basic other pricing for this. Once you apply, what happens next? So it goes into what's called examination. The USPTO is going to check for a few things. They want to see that the application is complete. They want to see that it's eligible for registration, that your trademark itself is eligible for registration for the class that you've picked or the classes that you've picked. And then they want to see whether or not that registration would cause what's known as confusion. So it's basically a conflict. Like you register something that is so close to another trademark that, nobody is going to be able to tell the difference between whether that is your trademark or theirs, or whether those two companies are the same. And usually the one with greater brand recognition or the one who's first in time is going to win out. The general note is once you've applied, like that 3 to 4 month rule, you should be checking the website, checking your email for what is known as an office action or response from the USPTO. It usually takes 3 to 4 months to get that back. And then it can take as long as 6 months, depending. 6 months would be a long time. I believe it's closer to 4. So anyways, next steps, it's either going to be those office actions or it's going to be notice of publication. I believe, for the most part, they're going to send you an office action. They're going to make you defend this thing a little bit. It would be pretty rare for you to actually just go straight into publication and not receive an office action on an application. No matter how good you are at this, it's usually the way things go. So what is an office action? It's an objection basically to your trademark application saying something about this needs to be changed. Something about this is deficient in some way. It can be like a deficient description. It can be, this is too similar to another trademark and here's why. And in these office actions, in some cases, they will give you the case law that they're sort of citing as the rule for why they think this is not going to pass the test for uniqueness and for use of the specimen in commerce. So The specimen and use of specimen in commerce issue is rarely an issue that comes up, but the truth is, like office actions about whether or not there would be a conflict do arise a little bit more. So, usually, like whenever we are doing this work, and whenever any lawyer who does this work, or anyone who does trademarks in general really does this, usually before you get into an office action situation, you want to do that research up front and make sure that, hey, we're going to get this thing most likely. And if not, here's why, and here's what we should change about this. Or in some cases, it makes sense for you to say, you know what, change the name, change the logo, change it all. And that's not an ideal situation, obviously, especially if you spend a lot of money on your branding. But the truth is, you should be looking at this as a nimble, flexible situation. You don't want to box yourself into just using like somebody's, using whatever trademark you have settled on for however long a period of time, especially if you get into an application situation and they're basically telling you, no way, you're basically infringing on these other people's applications, and here's why. And so or these other people's registered trademarks, and here's why. And so don't be too tied or too in love with the name or too in love with the logo that you've picked. Other than that, the next step after successful office action response, which does take some time. So each time you receive an office action, the waiting period for that is 6 months. You get 6 months to reply to it, which is a long time, right? You don't necessarily have to wait that long. You can if you want to. It kind of drags it out, though. So the idea there is, maybe fix that issue within a month or two, send it back to them. No big deal. There's no real reason to keep it waiting if you're trying to get that thing moving and trying to secure that as an asset. And it doesn't, and there's really nothing that goes against you either way, to be honest with you, in terms of the odds of you actually obtaining your trademark. It's just a matter of how quickly do you want this. We know some people who they don't care. They're willing to pay for the trademark, but they're just like, whenever, 3 years from now, 5 years from now, who cares? The truth is, it would probably never be 5 years. But the idea here is we try to keep it under a year. Because the idea is you have to. This is a service you need to have it done at some point, or at least know that you've been rejected at some point if it's not going to be successful. So, the other thing is, if you don't make technical corrections, you need to provide arguments, or you need to do both. And the arguments are going to be based in law, and it'll be sort of we disagree with this assessment, and here's why, and then cite the case law. And so what happens when a proposed trademark is set for publication? So it goes into the official gazette. The official gazette is published weekly, and anyone can view it. And actually, there are people who view this thing so regularly. In fact, it's all they do. And in some cases, I believe there are computer programs and algorithms written to spot and sweep for keywords, phrases, as well as symbols, and check certain shapes and things like that to ensure that those symbols and shapes are not too similar. There are third-party services that actually, when the publications come out, like, they go through them and see if they have any customers who have purchased like what is basically trademark infringement insurance, or the service for people to go after trademarks, or the service for people to oppose these logos or brand names or symbols that have been submitted for publication. And so an interested party can file opposition to a proposed mark within 30 days after it's published. Possible one-time extension of 30 days if interested party files a request to extend within the 30-day period. Interested parties can file good cause extensions, meaning we need more time. But the general idea is no more than 6 months. 180 days should be it. It shouldn't take any longer for us to figure that out. So if you resolve opposition by either defending and counterclaiming it or potentially resolving the opposition by agreement, you go into the next phase. And by the way, this last bullet on here, where it says potentially resolving the opposition by agreement, there are agreements known as trademark coexistence agreements, where you basically decide on how you are going to use a very similar name or a very similar trademark, a very similar trademark, a symbol or an object or something like that. And I mean, you agree not to step on each other's toes when you're using that to avoid any sort of confusion. I mean, the alternative to that is for you to basically purchase one person's trademark and acquire it. That's probably less common, but I mean, if you look on the website for the USPTO, there are spots on there where, I mean, they talk about what to do when a trademark has been assigned to another company or to another individual. And so it's just really a matter of how you want to handle that. Sometimes you are invested into that trademark and you actually do want to continue using it. And I mean, maybe that's just a matter of, hey, like, we're going to license it from this person who already has it registered, and we pay them monthly for it or something like that. There's no absolutes there, and you can do that a lot of different ways, but a coexistence agreement would probably be a good way to go. Other than that, though, once it goes through publication, what happens next? Certification of registration, meaning you're certified and you get like a paper certification in the mail. And then you have certain duties after that, but it's really no big deal. I mean, the idea, though, is you want to continue using it on a regular basis so that nobody thinks it's died out, so that nobody thinks it's gone away, or that you've gone away as a company. So declaration of continued use happens around the 5-year mark. So there are certain filings that have to happen between year 5 and year 6 after registration. You want to declare that you're continuing using it, using the trademarks, or if you're not going to continue using it, you can notify that you're abandoning it. Generally speaking, though, I think most people just go silent and they don't want to just notify because they think, okay, back pocket, I might just use this or sell it someday. It tends to last for 10 years, though. Like, if you don't file one of these declarations of continued use, I mean, there are grace periods of 6 months around that 5 to 6 year period. But I mean, generally speaking, once you've done that and it reaches the 10-year mark, you file the declaration of continued use between year 5 and year 6, and it goes to that 10th year after registration. All you really have to do is renew every 10 years after that. So a declaration of incontestability can be coupled with a declaration of continued use after that 5th year. And basically it means that a third party can't challenge ownership or challenge it on mere descriptiveness. And the idea there is nobody's come to do this before. Nobody should be allowed to really do this after. Even if we were infringing before on this, nobody ever challenged our right, title, or interest to the trademark. Fairly important there. You would definitely want to make sure you get both the declaration of continued use and the declaration of incontestability done. Doesn't really cost that much to renew those. Most lawyers will do it. Will do those sorts of things for should be less than $1,000 based on what I know of other lawyers' pricing. But so it appears that I have gone through pretty much every single slide on this. I went through pretty quickly. And so if I don't have any other questions, Trit, do we have anything else?
Doesn't look like we have any questions in the chat.
Okay. Yeah. So anyways, when it comes to trademarks, I would say I can just continue talking for a few more minutes about this and give you a little more specific. The reality is most people are going to charge, I would say somewhere between $1,250 to $3,000. $3,000 would be really expensive per trademark. I mean, unless you're getting tons of classes and they're just adding those individual classes to the trademark fee. The reality is like at a minimum, what you want somebody to do is to put together a research memorandum. Basically, it's basically a client letter to you saying, this is not like you are most likely going to be able to get the trademark. Here's why. Or if it's kind of a question mark, maybe you would say, you know, you could get this trademark, but it's likely that we will have to litigate or defend against somebody who's opposing it. There's somebody who we can identify that is reasonably likely to oppose it. We can't tell you for sure whether they would. Obviously, we're not going to notify them in advance because we would never do that. Though when it gets publicized, they'll be on notice of it. And so, I mean, when it comes to that process, like you can choose for the most part to pay a lawyer or whoever does this for a living to say, okay, I just want the research memo of this instead of for you to go do all of the filing stuff. Because I mean, if you think you're reasonably likely to get a trademark for this stuff, maybe go back to the drawing board and say, okay, what other classes can we get for this? What other products can we slap this thing on? What else can I brand? And go out and get as many goods and services classes as you can, which a lot of people do. They put it on everything, and then they try to get everything trademarked and trademark even the smallest little thing. And so, if you're not familiar with LegalZoom actually has an IP arm that does trademarks almost exclusively called Pulse IP. I can't tell you exactly what I think of them because LegalZoom is a different type of service than what we provide, right? So it's not the exact same as going to a lawyer's office. I mean, their stuff is going to be much more cookie cutter, much more. Here's the form, no legal advice on what to really do. You can pay to talk to an attorney, but usually it's not. I believe it's usually not included in the fee, or if it is, it's just an upcharge. I mean, the way a lot of people do this is they charge it by flat fee, and then the talk time is just included in it. I'm not going to charge you any more for that because that's what you're paying for anyway. I would say though, I would say trust Google reviews almost as much as you would trust the lawyer referrals you may get. Hey, if Pulse IP has 5,000 Google reviews and they're all 5 stars or 4.5 stars, that's probably an indication that they're pretty good at what they do. And that's not to say that we should. That's not to say that we should totally. Lawyers obviously want to defend their profession. I mean, the reality is lawyers work for Pulse IP too. It's mostly people who are just going to pump out trademark applications. We do a lot more of the service, and part of our draw for our clients is that it's not just trademarks. We do contracts. We do all the other stuff that goes with it. Buy, sell, what have you, small M&A. And that's what a lot of other attorneys who do trademarks do. I was talking to somebody about this the other day. If the attorney that you're talking to does exclusively trademarks, kind of a red flag unless they have a super robust practice. Because the truth is, almost nobody has enough business coming through to do only trademarks, unless that is all they want to do and all they're sitting around to do. And by the way, you're getting comparable services among different lawyers, among different services when you do that. There are competitors to LegalZoom. I know for a fact that there's one law firm that I think is based in the Pacific Northwest that does exclusively trademark work. If that's up your alley, you may go with them because I'm sure they've got a good reputation and they've got all this stuff down when it comes to responding to the USPTO, when it comes to dealing with them in a timely manner and speeding the process along and expediting things. So, when it comes to, I would look at whatever you're doing as I mean, if you're just looking for a transaction, maybe LegalZoom is right. If you're looking for somebody who maybe the person to advise you on an ongoing basis, might make a little more sense for you to go with a law firm. And so, I mean, I think that probably provides you with some good footing on where to go with that. Does anybody else have any questions? Because I mean, if anybody's still in the chat, feel free to ask as many questions as you want. I'm here for the next 15 minutes. I mean, the truth is, trademarks are I don't want to overstep, but trademarks are fairly straightforward compared to other forms of intellectual property. So it's my goal in the next video to discuss patents and when it makes sense to actually do those. But just to give you an idea, if you are the type of person who needs both a trademark and a patent, it may make sense for you to actually find a law firm that has an IP attorney that can do both. That's probably a better person to have on your side because, I mean, that person will do everything for you. And to give you an idea, like when it comes to a trademark is relatively inexpensive compared to a patent. A patent can cost $15,000 minimum, $20,000 minimum in some cases, and then there's really no ceiling on it if things get litigated, if things end up going badly with the application, or you end up somebody ends up trying to block your application. I know a lot less about that, by the way. Just to give you an idea, most lawyers are not licensed to do patent law. Lawyers who are licensed to do patent law have a technical degree, which means they probably got a degree in mechanical, civil, electrical engineering, maybe industrial engineering, or something of the like. Other people are allowed to do trademarks, but they're not allowed to do patents. I mean, I can only tell you vaguely what I know about that stuff. So, yeah, I mean, all good stuff. I mean, the truth is, I would say when it comes to the timing of when to get a trademark, probably the most common question, like when it comes up, is probably right after we've done a formation for somebody. We've started a brand new business for them. They finally picked out their logo. Like they picked a name a while ago. I mean, you can sign up for a trade name or an assumed name, something you can operate under that is not your legal name, and then you can brand that as well. And but most times people go, how do I protect my name? I'm worried about getting sued. Yeah, so I mean, to your point, like you were told to launch your website platform, then start the trademark process to show the business is essentially live. So yeah, I mean, once you launch your website and platform, I mean, you are showing people you're live. I would say what might make sense is, I mean, if it's really early on, launch it, get the brand on that thing, just from a preliminary standpoint, and then file that intent to use application. I mean, I don't think that's bad advice at all, but usually it does come sometime after launch or sometime after you formed the company is when we have that conversation. And I would say if you're worried about getting sued for trademark infringement, my first question is why? I mean, because really ask yourself, is that a high likelihood? Is there a high likelihood that you will? And I'm going to want to know if there is, or at least I would find out eventually, one way or another. The truth is though, like most people who are starting brand new businesses, most people who are getting off the ground right now are pretty much judgment proof. Also, you probably haven't conducted enough business to actually infringe on somebody else's trademark unless it's egregious and you're actually causing damage to their reputation or to their brand. So, I mean, there are certain instances where, I mean, that might happen. There are certain instances where trademark infringement or misuse or tarnishment of a mark might come into play. If you've ever followed news related to the car company Ferrari, apparently Ferrari is pretty fierce about defending the prestige of their brand, and they do not allow people to tarnish it. They do not allow people to take improper pictures of it, post it on social media without sending those people a cease and desist letter. And for some people, it's actually a game. So and some people, they're intentionally provoking them to make news. And, in some cases, bad publicity is actually, publicity, any kind of publicity is good publicity, because if you made the news because you infringed, and somebody actually did threaten to sue you, they might, my first impression would be they must view you as an actual threat to their brand, like a financial threat, if they're willing to do that. So, but typically the way it goes is somebody sends us a really threatening letter because we represent you, or they'll send your lawyer or send it directly to you, your company. And you'll basically just hand that off to somebody who will respond to it. And then you'll either come to an agreement to stop using the mark, or you'll come to an agreement to, or you'll basically just continue using it and just tell them, okay, well, we believe we have title to it, or we believe you're wrong. That happens sometimes. So in reality, the timing of this, I would say, don't get bogged down in the financial aspect of it, though, because the problem is it is a more expensive service than some of the other stuff we do that can help you launch your business, and some of the other stuff lawyers can do to help you launch your business. It would probably be better if you had a contract drafted to help you earn money before you started applying for a trademark, unless you want to self-fund the trademark application process itself. So, financially, there's a pro and a con and a balancing act that you have to do. For some people, they'll ask me about it, and I'll say, I've been doing deals for you. I can tell you guys don't have that much money. In that case, I would tell them, wait on the trademark. It's always going to be there. No big deal. But in other cases, I would say, if it's a hard product, maybe an e-commerce website, maybe it makes sense now to start that process. Get a provisional one or provisional application set up, and then move forward with, and then just move forward with the application once you're ready. Because we can get you set up with maybe a domain name, like trademark registration, or somebody else could do that, or you can go through one of the third-party services, or start that process for you. And then, once you figured out what you're going to sell, what you're going to put the brand on, the classes that those will fall in will be determined by whoever's helping you do this, or if you're doing it yourself, it'll be done by you. And then, you'll see whether or not you get those once you amend your application and it goes into the further process and goes into office action territory and eventually publication. So, do we have any other questions? I can continue rambling, but really, if the group wants to direct, where the conversation goes, I can go ahead and do that as well. The reality is, I would say, whenever you've applied for a trademark, you can always go back and say, hey, I want to get another class for this. It doesn't have to be all at once. So you don't have to sit there and go, I want 15 separate goods and services classes. It doesn't have to be, it doesn't have to be that way. You can get the minimum that you want right now to secure your intellectual property, to preserve that for you. And then you can branch off into the other goods or services classes that you want, which, the goods and services classes, to give you an example, there's food and beverage, clothing items. It's all sorts of things. And it actually is meant to be pretty expansive, but the classes themselves are meant to be pretty narrow, so that, it would be pretty clear based on the product that you're putting your logo or brand on, or whatever you're doing, service-wise, which class you fall into. And then if there is any sort of potential conflict, it's just a matter of arguing with the USPTO and just proving that up, and just saying, hey, no, here's why this belongs in this class. Here's the case law on this, or here's the statute, here's whatever this says. There's no strict science to doing all of this, but it is fairly defined. I mean, just from a general standpoint when you're approaching it. As office actions come in, though, I mean, certain issues come up, and sometimes it's just luck of the draw on the attorney that you get from the USPTO. I mean, no really predicting whether or not you're going to get a very congenial, easy to work with person or somebody who's just going to say no all the way through. Usually, though, we try to avoid getting a straight up rejection. And I would say that I think a lot of other lawyers are probably the same way. And the reason has to do with we don't want you getting flat out rejected for whatever you're using, because we still want to preserve potentially the ability to go back and refile or what would I say, revive the application. So one of the things I didn't talk about, which I could talk about the last 5 minutes, is what happens when you don't continue pursuing an application. It's considered abandoned, basically. If that 6 month period passes and after you receive an office action and you don't respond, it's done. But it's not done forever. You can revive the application by filing to revive it. I believe there's like a penalty to do that, but if you really want it, it's negligible compared to the just so the other interesting thing that I do want to talk about, which I wish I'd included a slide on this. I was watching Shark Tank the other day, and I hate using Shark Tank as an example, but these guys who were on there, they revived somebody else's abandoned trademark, which I thought was really interesting. That does not happen that often, like really ever. I mean, these people found what was a former childhood toy that was no longer being made, which had a formerly active but now abandoned trademark. And then all of a sudden, apparently they came in and revived the trademark and actually got it back to active status. That is something you could do if you were found a good enough brand that had been abandoned and it did not conflict with anyone else's brand or logo or brand name or anything like that. Like it's possible that you could do that. It's an uncommon option, but if you were at a loss for what to do, you might just go searching the dead trademarks and narrow it down to those to see which ones you could steal. Because they're just out there apparently. And if people aren't using it, maybe they would say, we actually have a claim to it. Like it's ours. It should never have been abandoned. But in reality, you may be able to argue that no, you abandoned it. We're reviving it and paying the money to do so. It's ours now. And in some cases, some of the companies will have gone bankrupt, and those people who used to run them are no longer running them. In some cases, they might be dead. Truth is, you might actually be able to, get out of that situation by just finding a very old one. Pending bills in Congress to help trademark holders. I'm not entirely sure. I would have to read. I usually, to give you an idea, while I do try to stay abreast of pending bills, I usually don't read that much into them because they're pending and they're proposals. I don't spend a lot of time reading proposed bills, only because until they become law, they have absolutely no legal effect on what we do. Unless of course I can see the signs and they're absolutely likely to become law. In that case, might pay a little more attention, but yeah, I'm not entirely sure what it might say. If you might clarify your question or send me an email if you want to know something more specific. But anyways, it looks like I'm approaching the end of my time here. If y'all have any more questions, please feel free to reach out to me at kyle@joneskertz.com. Always available to help y'all out and answer any one-off questions that you might have. Part of this is about mentorship and about education, and not about selling my business to y'all. So definitely reach out if you ever need anything. I'll be in Dallas. I'll be in Austin. Feel free to drop me a line. Anyways, take care, guys. Thanks for coming, and I will see y'all next month. Bye.